And joining us now is attorney Ian Friedman. Ian, thanks for being with us.
Thanks, Chris.
You are a defense attorney. I'm going to ask you to put on your prosecutorial hat here today. Is there enough in this document to indict these officers?
You know, indicting someone is so much easier, of course, than we always hear about proving someone's guilt in a court of law, beyond a reasonable doubt. All you need is a very low threshold of probable cause, and it's very easy to indict. The defense isn't there. They're not putting up any sort of defense. It's a very low standard. So can they indict? Yes. I hope, however, that there is some thought as to whether or not the case can be proven beyond a reasonable doubt later in court. I think that's where the difficulty would be.
What is the most damning thing in this report if you're the defense attorney for Officer Lohman?
Well, I think the most damning thing is what struck everyone, how the car came up so quickly. Everything happened fast.
2 seconds.
2 seconds. And so people will ask, well, wait a second, why couldn't the car have just stopped sooner? Why did there have to be this interaction, this challenge so quickly? So I think that's going to be probably the thing that strikes people first, the biggest question.
What is the most exonerating fact here?
You know, I really think this is a difficult case to make. I mean, the fact of the matter is you have to look at what's inside the mind of Officer Lohman. And he's put in a position where he's told that there's a person with a gun, and later they learn that it's a kid, but you hear from many people who responded. He looked like an older teenager when they arrived, and you see the tape. He reaches, for his waist, and the officer was heard saying, "I had no choice." This really just seems to be a responsive action. The officer acted so quickly that he himself stumbled backwards and sprained his ankle. I think when people really think about it, if they can do so objectively, he was really put in an almost impossible position.
The speed with which this all moved, and as you said, it was 2 seconds by the time they got there and the shots were fired. Judge Adrian, whose court this week said that there is probable cause for a charge here, for an indictment here, talked about how speedy this was, almost in a way that was not proper. The speed here also an underlining point.
And again, Judge Adrian's looking at the level of probable cause the same way that a grand jury would. He has concerns that many would when they first see it, the speed of it. But what I think he's pointing out will be more likely looked at as kind of a protocol violation, practices for the Cleveland Police Department as they move forward. But there's a big difference between a violation of policy and a violation of criminal law.
Why did the prosecutor release this now? It seems like the timing is important to McGinty's office.
I think it was a very smart decision on Prosecutor McGinty's part. He saw how in other cities, we saw in Ferguson, the prosecutor got up there and said, "Here's the decision the grand jury has made," and people reacted. We saw in Baltimore the prosecutor just say, "Here's the decision I've made," but the reports, the information, the data collected was not given to the public. Here he's saying, look, the Sheriff's Department did the investigation, it's all here, as soon as we got it, we're putting it out to the public. I think it lets the public understand how decisions will be made later on.
Takes a little air out of the balloon maybe here as well.
I think it does.
And the next step here is the grand jury, and that could be weeks, it could be months.
Yeah, you also now have to look at the statement that was put on the prosecutor's website. And Prosecutor McGinty, as it correlates to this, just simply said, this case, as with all force and police abuse cases, will go to the grand jury. And so he's just being very official. Here's the info. A grand jury will decide.
Okay, Ian, as always, thank you.
Yeah, thanks, Chris.